And to finally touch upon what I have been called to talk about is the Croatian side of the story, but as the slide says, it will be rather short note from here because for various reasons we have not yet in Croatian competition law started to discuss the compliance program, and to keep it with medical terminology, simply if there is no pain and no sickness, there is no need either for prevention or for cure. And the pain and sickness in this case being the successful and efficient enforcement of competition law. Basically, for various reasons, criminal liability, although can be construed, has not been invoked. Civil law damages claims not really happening, and sanctioning by the regulator, by the competition agency, again for various reasons, up to now was not that efficient. So basically there was no incentive for purely, let's say, domestic companies to put any effort into compliance program, to put any effort to prevent being sanctioned. What we have seen a lot is import of compliance programs from international corporations operating subsidiaries in Croatia. And in this context, obviously, as Pavel also mentioned, some localization will be required, and I believe that the emphasis here will not be on substance of the program, because if something functions within the ambits of Articles 101 and 102, it will well function within the Croatian competition law, especially if the messages are simple, like do not talk about the prices with your competitors. The thing that requires localization is obviously procedural side of the story, data protection and other, let's say, little bit not that connected parts of compliance program. And this localization will be more required into, for example, procedures for dawn rates and that kind of stuff. But again, the thing is that we haven't seen any of those in Croatia yet, so we can just localize programs in that respect based on the black letter of law, which will not necessarily be successful. So what we need to boost the compliance culture, I think, in Croatia is two levels of advocacy. First, advocacy saying what we have heard, that compliance with competition law does good to the company, does good to the economy as such, because we have agreed some time ago that effective market competition is good for everyone. So that kind of soft advocacy will be required, but also advocacy with a whip by the regulator, with levying fines, appropriate fines for violations of competition law. And to conclude with just thank you, and obviously if I have, and it's quite possible, said something wrong or missed something, please do let me know, because as I said in the beginning, this is just like a share of thoughts, because these guys before me covered everything that actually you need to know about effective compliance programs. Thank you.
Well, thank you very much, and I think it was also a good summary of this panel. Nevertheless, if there is any question, we are happy to answer to. Well, if no questions, then thank you very much.
All companies are compliant. Yeah.